Well, hello everyone, and welcome back to AJ507 Ethics in Criminal Justice. My name is Tony Farrar, and of course, I am your instructor for this semester. So, this week's lecture is going to cover Chapter 8, where we're going to take a look at the law and legal professions. All right, so we have a lot of content to cover as usual, right? So let's go ahead and just kind of jump right in. So, some of the learning objectives we're going to take a look at and describe some of the justifications for law. Why do we need it? Things like protection against harm, offensive conduct, harm to self, and also harm to society, or societal morals, as they call it. We want to be able to explain the role of law in society and the paradigms that have developed to understand how law is formed. And we'll discuss what a paradigm is if, in fact, you're not familiar with the term. Next, we will compare the idea of our criminal law system as an adversarial system to other descriptions of how the courtroom works and those relationships between legal professionals, those players in the system, right? The prosecutor, the defense attorney, the judges, etc., the jury, all of those folks. We'll look at some of the controversies concerning the role of kind of advocate as a legal agent or a moral agent. And then finally, we'll finish up describing the history and source of legal ethics for attorneys and judges. So we'll take a look at all of that. Again, a lot of information to cover, so we need to just kind of jump right in. So Michael Morton went to work early, in the early morning hours back in 1986, never really realizing that his life, as he basically knew it, was going to be over. You see, when he arrived at his house, he found crime scene tape, police officers, and also crime scene investigators. And that morning, a neighbor had found his 3-year-old son wandering in the neighborhood covered in blood. And subsequently, his wife had been beaten to death. So, as a result of all that, Morton was later arrested, charged, and convicted. And the only real evidence was a note he left taped to the bathroom mirror that basically rebuked her, the wife, for not having sex with him the night before. So it's kind of like one of those smarty notes, if you will, right? Like, why didn't you do this? And thanks a lot, or whatever. But anyway, there was a note that was taped to the bathroom mirror. And as a result, he was incarcerated for 24 years. And during all that time, he continued to say that he was innocent. Now, fast forward to 2011, he was released because DNA evidence proved that he was innocent and another person was guilty of killing his wife. And it was later determined that the prosecutor did not provide the defense with some of the evidence, that evidence which was a bloody bandana that was found near the home, which later had the victim and suspect's DNA on it. So you can already see the issue, right? Now, the Innocence Project, which is a group of lawyers, and they kind of play into this because they really do focus on DNA. These are kind of attorneys in a loosely affiliated group that use DNA specifically to help exonerate individuals. And they have successfully achieved the release of approximately 349 people as of the summer of 2017. And it also seems that, every week or so in the media, we see some kind of new case, where an individual who may have spent decades in prison for a crime he or she did not commit, that more than likely was possibly cleared up by DNA, right? And just to kind of give you another thought before we move on, while the most common factor in these convictions actually is mistaken identity, we do have to consider any other unethical acts of police or prosecutors. So, to kind of summarize the story, the Michael Morton case really is only one case of many where innocent people have been exonerated, again, usually based on DNA. Now, the National Registry of Exonerations, a project of the University of Michigan Law School, University California Irvine, and the Newkirk Center for Science and Society, and the Michigan State University of Colleges of Law, currently lists a little over 2,000 exonerations that they have documented since 1989. And again, I talked about the Innocence Project. Now, just as Ferguson, Missouri, and Baltimore, Maryland have triggered a national conversation about police, so too have highly publicized exonerations like the Michael Morton case, right? It kind of triggered a national consciousness that the justice system sometimes can create some injustice. Now, I'm sure, and a lot of research has documented this, that these witnesses, they don't lie for the most part, 99%. They don't lie. They believe that they're actually identifying an individual that they believe was the perpetrator of the crime. But there are a lot of other factors that we have to consider, okay? Such as the case here where the attorney did not turn over certain exculpatory evidence. But, also, just as with law enforcement, the focus has targeted the actions of prosecutors, judges, and defense attorneys, since it is they who are are instrumental in making sure that the system works. It's not just the cops on the street. It's a lot of the other actors under this criminal justice umbrella, right? So, in other ways besides wrongful convictions, individuals in the system dramatically affect individuals' lives. So, what we're going to kind of focus on in this chapter is we're going to look at the ethics of the legal professionals. We'll examine some basic issues concerning the role of law in society in the same way that we looked at the history of policing. And we'll also take a look at some of the formal and informal ethical codes that guide some of these legal professionals' actions, just like we did in Chapter 5, where we took a look at the Law Enforcement Code of Ethics, right? And also we talked about law enforcement subculture. So, what then is the role of law? Well, our laws serve as the written embodiment of society's ethics and morals. And we've talked a lot about that already. And laws are said to be kind of declarative as well as active. They declare correct behavior, but they also serve as a tool for enforcement, right? And we're talking about, the laws administer justice. They, enforce rights. It can be used as a tool of behavioral change. And it's also educative. So as we kind of take a quick little history lesson, right? While natural law refers to the belief that some law is inherent in the natural world and can be discovered by reason, if you will, positivist law refers to those laws written and enforced by society. So here under natural law, again, believes that individuals naturally possess certain freedoms that may not be encroached upon by other individual governments. And again, positivist law refers to those laws written and enforced by society. And many also believe that for, that positivist law to be legitimate, it must be created and implemented in ways that are acceptable to most people. And this type of law is of human construction again, but keep in mind, because it is of human construction, a lot of critics say it is therefore fallible, and we know that sometimes it is, right? So we, if we're kind of honest. But, kind of finishing up this thought, not everybody agrees, right? So you have some kind of think this way and some that kind of think that way. So it's up to you to kind of decide, well, what do you really think? So what is law then by definition? Well, laws are, the short version is formal written rules of society, but kind of a broader definitions. Law is defined as that which is laid down, ordained, or established, a body of rules of action or conduct prescribed by the controlling authorities, whoever that might be, and having binding legal force. And that makes sense, right? Because it wouldn't be a law if there was no punishment, if you will. So, and one thing to kind of consider before we move on, not all rules are laws, and not all rules have binding legal force. So we have laws and we have rules, and we should know that there is a difference between those two. So we can trace the history of law back to some very early codes, like the Code of Hammurabi, which basically mixed secular and religious kind of prescriptions of behavior, if you will. And these codes also standardized punishments and atonements for wrongdoing. Now, early codes of law did not really differentiate between what we know now distinguish as public wrongs, criminal law, and private wrongs like torts, right? Criminal law is more closely associated with enforcing the moral standards of society, yet it is by no means comprehensive in its coverage of behavior. So, as we kind of look at this again, just keep in mind, the Code of Hammurabi. And again, well-preserved Babylonian code of law, written, of course, of ancient Mesopotamia, dated back to about 1754. It's one of the oldest deciphered writings, of significant length, if you will. And then we have the Code of Urnamu, which is the oldest known law, written, right, because it's on the tablet, surviving today. Only part of it. The whole thing wasn't, they weren't able to get the whole thing, excuse me. It's also from Mesopotamia, and again, written on tablets in the Sumerian language, excuse me, and dates back to about 2100 BC. And then just a couple of other things to kind of throw in here, knowing as we talk about the role of law, as we got to the, the English courts, etc., note that the decisions of the highest court, which would be the King's Court at that time, were binding across England. And over time, these courts developed their own processes and rules. And one of these important pieces would be what we call stare decisis, which basically means let the decision stand. And, it's a Latin term, but it embodies the idea that cases with similar facts should have the same law applied, right? And the earlier case is commonly known as precedent. So today, we still have this principle. And this principle establishes that a previous legal case is either binding or persuasive for a court when deciding subsequent cases with similar issues. And the United States Supreme Court uses this stare decisis, if you will, when they look at and examine or interpret current cases that they're dealing with. Now, finally, common law. These are laws originating from the use and custom rather than from written law. So it kind of refers to non-statutory laws, right? Those types of laws that that are not written. Basically, again, customs and things like that. So that's kind of how they basically used law back then. Okay, so finally we'll finish up with something called the Good Samaritan Law. So the Good Samaritan laws, or some exception to some of these other laws, would be the Good Samaritan laws, which are very common in Europe and are basically legislative efforts that prohibit passing by an accident scene or witnessing a crime without rendering some type of assistance. And these also refer to laws that provide protection from civil suits for a person's, or medical professionals who render aid. So if you were in that medical profession, let's say, and somebody was hurt and you went to render aid, this Good Samaritan law would basically kind of cover you, if you will, if by chance maybe you did something to help and it turned out that it was more of a hindrance. Now, an interesting thing to show you before we kind of move on would be AB472. And this is California's 9/11 Good Samaritan law. And let me read it to you. It shall not be a crime for any person who experiences a drug-related overdose as defined, who in good faith seeks medical assistance, or any other person who in good faith seeks medical assistance for the person experiencing that drug overdose to be under the influence or to possess for personal use a controlled substance, analog, paraphernalia, etc. So what this is trying to say is that we've been having so many drug overdoses across the U.S. that California and a lot of other states have adopted something similar, but people were afraid to call when they were perhaps using drugs with somebody else, when they would either witness an overdose or actually overdose themselves. They didn't want to call because they could be subject to arrest for being under the influence or possessing small amounts of illegal narcotics, etc. So this Good Samaritan law is kind of a little different in that if you call for the reason to help someone to get medical assistance, then the focus comes off of you, and that law enforcement really is to I kind of hate to say it like this, turn a blind eye, because the reason that they're there in the first place is to render medical aid. So it's a very controversial type thing. And some see this as kind of good, and some see this as kind of not good. But again, this is, the role of the law. And we know that laws continually change, right? So kind of an interesting thing for us to look at. If you want to know some states that have overdose immunity laws, here's a little snapshot of the U.S., and you can kind of take a quick look. Okay, so what now then are justifications for law? So we've talked a little bit about history and what are laws, etc. So the major justification for corrective or criminal law is the prevention of harm to persons. Now, under the social contract theory, law is a contract, and everyone gives up some liberties and in return is protected from others who have their liberties restricted as well. So kind of an interesting thing, right? But how much liberty really should be restricted, and what behaviors should be prohibited? And that's kind of a balancing act for law enforcement as well, because they know that, people are going to give up. Like when you go to the airport and you go through the screening thing, you're giving up some liberty. The Fourth Amendment talks about, search and seizure and all that kind of stuff. But because of, terrorism and, acts of violence and all the other things, you're giving up a little liberty, which is the search and the x-ray and all that stuff, in order to fly safely, right? And that's kind of what they're talking about here. So, that's the social contract theory. And here's a kind of a little picture, if you will, of Locke's social contract. Okay, so that's kind of, if you want to, kind of look at that. So, again, still staying under the justifications for law, the justifications for law that are most cited are preventing harm to others, preventing offensive behaviors, preventing harm to self, and protecting societal morals. And we're going to kind of take a look at those now briefly. So, John Mill basically proposed what we call the harm principle, which basically is the idea that every person should have the utmost freedom over their own actions unless those actions harm others. Now, in this view, the law would restrict only those actions that can or do cause harm to others, things like assault, attempted murder, or theft. And again, remember that most of our criminal laws are created to punish individual harms. So we do have to kind of keep that in mind. So, again, most of our criminal laws are created to punish individual harms. The harm principle, by definition, would be to prevent harm to persons other than the actor himself. Okay. And there are some actions that do not exactly harm others, but do give rise to us to kind of think about, right? When we talk now about, preventing offensive behavior, that would be things like public lewdness or disturbing public, type behavior, noise, or other actions that infringe on the quality of life of others. Those can be the subject of laws, and individuals who basically flaunt such laws may be fined or punished in certain ways. Now, these particular laws, when we're talking about, the offense principle or preventing offensive behavior, these laws are sometimes controversial, right? Because there can be this argument that, law shouldn't restrict a person's behavior if it only creates inconvenience or disgust and it doesn't damage the other person's interests. And we all have a different, part of this thought process is that we view offensive behavior differently. So again, the offense principle that falls under preventing offensive behavior is to prevent serious offenses to persons other than the actor, things again like public indecency, lewdness, etc. So a lot of things to kind of think about with this one. And then you have preventing harm to self, or what they call legal paternalism. And by definition, legal paternalism refers to laws that protect people, right, from hurting themselves. So, many laws can be described as examples of legal paternalism. Laws which states try to protect people from their own behavior. Examples could be seatbelt laws, motorcycle helmet laws, speed limits, some drug laws, licensing laws, alcohol consumption and sales, smoking prohibitions, and certain types of sexual behavior. Those can all be kind of put in there. Now, of course, the strict libertarian view would hold that the government has no business interfering in a person's decisions about these types of behaviors, and if they don't negatively affect others. Now, the opposing view is that if a person is a member of society, and everybody is, right, he or she has a value to that society, and society therefore is compelled to protect the person with or without their cooperation. So again, another kind of interesting point. And part of this preventing harm to self or legal paternalism, the rules try to create a balance between that individual's liberty and government control. And, paternalistic laws can also be supported by what we call ethics of care. And in this framework, morality is viewed as as integral to a system of relationships. And we'll talk a little bit more about that as well. Meaning the individual has ties to society and to every other member of society. So, rights are less important in this framework. Therefore, to ask whether society has the right to interfere or an individual has the right to a liberty is not relevant, really. So, current debates regarding laws that attempt to influence people's lifestyle choices, like smoking, etc., kind of illustrate the debate, if you will. So there is a debate. Then we have what we call legal moralism. And this is basically preventing harm to societal morals. And you're probably going, can we do that? Well, let's talk about it for a second. So in legal moralism, law is the moral agent of society, some say, in areas where there really is no moral agreement. And this rationale is called legal moralism. So, think about it. Some sexual behaviors, gambling, drug use, pornography, even suicide and euthanasia are defined as wrong and are prohibited. And the laws, against these behaviors may be based on principles of harm or paternalism. But they also exist to reinforce society's definition, if you will, of moral behavior. So, kind of going on still, whether an action is moral or immoral is kind of a different question from whether there should be laws regarding the behavior. Now, in limited legal moralism, there are laws only when the violation is of a kind of universal standard of morality, as opposed to merely a conventional standard. So this kind of prevents the situation of some groups forcing their moral code on others. Okay, so again, kind of an interesting type thing, right? And more so, there's a gray area when we talk about this, because many see these laws really not as black and white. Therefore, it comes into question whether they're wrong or not. And we know that public views on things over time tend to shift, right? Examples could be same-sex marriage. Examples could be drug use. A great example would be the legalization of marijuana, where years ago it was unheard of and it was illegal and there were all these laws. And now we know that public perception has changed, and now in certain states, not only is medical use acceptable, but so is recreational use. And I thought I'd kind of throw this in there. So here would be legalized for adult use. It'd be the green states. Legalized, allowed for medical use. Okay. And then finally, basically decriminalized, meaning that it's not against the law, period. So kind of interesting. And then finally, one that your textbook sort of touches on, but I want to make sure that we covered it. Another kind of justification for law would be benefits to others. And this really is to provide some benefit to persons other than the actor, which could be things like toxic waste, etc., illegal dumping and those types of things. So maybe, environmental type issues, if you will. Okay, so let's go ahead and kind of keep on going here. So now we're going to talk about paradigms of law. So our understanding of the law's function in society is formed by more fundamental views of the world around us. And these are typically called paradigms, right? It's kind of a fundamental view of the world around us and how we kind of conceptualize it. Basically, paradigms are models of how ideas relate to one another, forming a conceptual model of the world around us. And a paradigm helps us to organize the vast array of knowledge that we absorb every day. We see the world and interpret facts in a way that is influenced by our paradigm. And paradigms, aren't bad or good. They're simply a function of how the human mind works. And our paradigms can also shift, of course, when we're confronted with overwhelming facts that come from trusted sources or personal experiences that are contrary to our original thought process or our original paradigm. So, with that said, there are three paradigms that might affect our view of the law, because remember, that's what we're talking about, whether, we are legal professionals, legislators, or citizens, and these would be the consensus paradigm, the conflict paradigm, and the pluralist paradigm. So the consensus paradigm views society as a community consisting of like-minded individuals who agree on goals, etc., important for survival. So in the consensus paradigm, law serves as a kind of a tool of unification, if you will. And hopefully that kind of makes sense. And law contributes to the collective conscious by showing us who is deviant. So in this consensus paradigm, we see a couple of different factors. Okay, first, that law is representative. It is a compilation, if you will, of the do's and don'ts that we all agree on. Next would be that law reinforces social cohesion, meaning it emphasizes our kind of we-ness, if you will, by illustrating deviance. And then finally, that law is value neutral. That is, it resolves conflicts in an objective and neutral manner. So next we have the conflict paradigm. And the conflict paradigm views society as being made up of competing and conflicting interests. Now, according to this view, governance is based on power. If some win, others lose. And those who hold power in society promote self-interest, not necessarily a greater good, if you will. So this perspective sees law as a tool of, power holders to maintain and control the status quo, and those who control major social institutions then determine how crime is defined. So, the regulation of business instead of the criminalization of harmful business practices arises from the ability of those in power positions, again, to redefine their activities to their own advantage. And generally, the conflict paradigm kind of addresses these three factors. And we're going to kind of cover those right now. So first would be that law is repressive, meaning it oppresses the poor and powerless by differential definitions and or law enforcement. Next would be that law is a tool for the powerful. Those who write the laws do so in a way to promote their economic and political interests. And then finally, law is not value neutral. It is kind of biased and bent towards the interests of the powerful. So that's the conflict paradigm. And then finally, we have the pluralist paradigm. And the pluralist paradigm shares the perception that society is made up of competing interests. However, pluralism describes more than two basic interest groups and recognizes that the power balance may shift when interest groups form or coalitions emerge, if that kind of makes sense, right? So when maybe groups kind of get together. So under this pluralist paradigm, the concept that there are many groups in society and that they form kind of allegiances and coalitions in a kind of a dynamic exchange of power. And law arises from those interest groups that are in flux. And also, finally, that the definition of crime may change depending upon which interest group or groups have the power to define criminal behavior and what is currently perceived to be in the best interests of those most powerful groups. So hopefully that kind of makes sense. So those would be the three different types of paradigms. Okay, so we're going to kind of finish up one more section and we'll take our first break. So, you know, your textbook titles the next section calling, it says here, first, let's kill all the lawyers. Well, this is more of public perception, okay? And that's kind of where we're going to go a little bit. So the public perception of lawyers kind of indicates that the public has little confidence in lawyers' abilities to live up to the ideals, if you will, of equity, fairness, and justice. Perhaps the best explanation for the long-standing distrust of lawyers is that they typically represent trouble, right? And because really, people don't require a lawyer unless they believe that a wrong has been done to them or they need it to be defended, right? So they must be, either they thought they were been wronged or they are wrong and they need some kind of defense. So kind of an interesting chart that I pulled off of a survey from the Pew Research Center talking about the percentage, if you will, of trust. And you can see here from 2016 to 2019, nurses, engineers, you have doctors, pharmacists, dentists. I don't know why dentists are up there. I completely hate dentists, but anyway, you have police officers, right? So they're right in there. Gone down just a little bit, but, teachers, etc. But kind of look at the bottom. Car sales folks, members of Congress, senators, governors, stockbrokers, attorneys. So you can see that a lot of people don't really trust attorneys, right? And again, the perception of the lawyer as an amoral hired gun is in sharp contrast to the ideal of the lawyer as an officer of the court, sworn to uphold those ideals of justice, right? And the public does tend to agree with a stereotype of lawyers as amoral, motivated by money, and really with no conscience or concern with morality. So they kind of agree with that. And the ideal of the justice system is that two advocates of equal ability are going to engage, in a pursuit of fact-finding and truth, guided by a neutral judge. And it's kind of interesting when you talk a little bit more about this. See, you can even go back from ancient times. The ethics of those associated with the legal process has kind of been suspect a little bit. Okay? And we'll finish up just talking about this and we'll take our first break. Even Plato and Aristotle condemned advocates because of their ability to make the truth appear false and the guilty appear innocent. That's kind of an interesting comment. And this early distrust continued throughout history. even early colonial lawyers were distrusted and even punished for practicing law. And apparently even lawyers themselves don't think a lot about their profession. A national law journal study found that over 50% of attorneys describe their colleagues as obnoxious. And that's kind of, interesting, right? And in one study of 6,200 attorneys across 4 different states, lawyers with the highest incomes weren't happy as lawyers working in public service jobs for substantially lower pay, meaning that they didn't want to be public defenders because you don't get paid a lot and it's not as glamorous. But gee, isn't that their job? So, I mean, you can kind of see where this is going from. So they want the high-paying money jobs. And least happy were those general practice family law and private criminal defense attorneys. In a 2006 poll, about 55% of attorneys were satisfied with their career, and only about 44% of, all lawyers would recommend it as a career. So again, the ideal of the justice system is that we have 2 advocates of equal ability that are going to engage in a pursuit of truth, guided by a neutral judge. And the truth is supposed to emerge from the contest, right? Now, actual practices in our justice system may be a little bit different. But, really ask the question, and we'll stop here. Does the best opponent always win? So we'll take our first break. So that'll conclude part 1 of Chapter 8, Law and Legal Professionals.